I move the Amendment 70 in my name, which is to remove a reference.
And it's reached, it's been discussed now. Can be discussed now,
Oh, sorry, yes.
later.
Well, I intend moving it.
That's correct.
I want to say a few words about this whole bill. I fully recognise that the former Attorney General, Paul Gallagher, embarked on a massive task in seeking to consolidate planning law and to update it in the manner that this bill provides. And it was a project which he took personal interest in, and it's impressive in its size. But I have to say that I've come to the conclusion, looking at the bill itself, that this is not a step in the right direction. I think it's a step in the wrong direction. For many, many reasons, I believe that to be the case. Senator Higgins has just referred to the National Planning Strategy and the National Planning Statement. And I look at these provisions of this Act and the central function that is given to the Office of the Planning Regulator in relation to the enforcement of those instruments of national planning policy with some degree of scepticism and I have to say a growing sense of horror. We are now ignoring our solemn international obligations under the Council of Europe's treaty to do with local government. Ireland amended its constitution by putting in Article 29A to recognise at a constitutional level the whole principle of local government, and it did so on foot of an international treaty obligation that this state voluntarily undertook to accord constitutional and real substantial status to local democracy. And I judge this bill, and in particular the position of the Office of the Planning Regulator, by reference to whether the spirit of that European Charter on Local Government, to which we signed up, is being met or not being met. And I just remind the House that the concept of local government, first of all, each adherent said that the principle of local government shall be recognised in domestic legislation and where practical in the Constitution. So we did it. We put it into the Constitution that there would be constitutional recognition. Then the concept of local government was stated to be the following. Local self-government denotes the right and the ability of local authorities within the limits of the law to regulate and manage a substantial share of public affairs under their own responsibility and in the interests of the local population. And the Charter also states, this right shall be exercised by councils or assemblies composed of members freely elected by secret ballot on the basis of direct, equal, universal suffrage, which may possess executive organs responsible to them. This provision shall in no way affect recourse to assemblies of citizens, referendums, or any other form of direct citizen participation where it's permitted by statute. And then the Charter says, the scope of local self-government, the basic powers and responsibilities of local authorities shall be prescribed by the Constitution or by statute. However, this provision shall not prevent the attribution to local authorities of powers and responsibilities for specific purposes in accordance with the law. Local authorities shall, within the limits of the law, have full discretion to exercise their initiative with regard to any matter which is not excluded from their competence nor assigned to any other authority. And that's the point. We have internationally said that we are giving local authorities full discretion. And at the same time, you look at this Act and you say, nearly every bit of it is a detraction from local discretion. Nearly every single bit of it is a step back towards centralised oversight and administration of local government. Now, Senator Higgins referred to the provision of Section 25, national planning statements. And national planning statements, as I understand it, are intended to replace what used to be ministerial guidelines. And interestingly enough, there was a considerable volume of High Court decisions in relation to ministerial guidelines, which were expressed at the time that they were originally introduced as being matters to which local authorities should have regard when they were making decisions. That was the principle of it. But it's slowly transformed now into directives, effectively, dressed up as national planning statements. That the minister has been given a power under Section 25 of this Act, when it's made into law, to lay down national policies in relation to planning matters to support proper planning and sustainable development, and guidance as to the administration implementation of them, and to publish these on a website, which is fine if you want to have guidelines and if you really are leaving discretion with local authorities under them. But then, and this is where I really do have to express fear, we then go on to establish the consequences of, for instance, national planning statements, and what happens and what their effect actually is. And if you look at Section 36, you find that the Office of the Planning Regulator has extraordinary powers to effectively inquire as to whether decisions being made in the planning realm by local authorities comply with ministerial statements, planning statements, and to require the cancellation, effectively, by direction of aberrant local authorities' planning decisions and practices on the basis that they are not consistent with ministerial statements. So we have a national spatial strategy which is adopted by the government in its entirety, but we have what used to be planning guidelines, now rechristened national planning statements, which are policed by the Office of the Planning Regulator, and which in effect are made mandatory as regards local authorities. And I saw a number of planning decisions where the court said, well, the old guidelines were things to which planning authorities had to have regard, but they weren't bound by them. But the department twisted the screw by successive legislative measures to make sure that having regard to actually now meant obeying ministers' guidelines and not contravening them. And what we're doing here is we're putting into law this provision for the Office of the Planning Regulator to effectively to police the activities of local authorities, and to, throughout this bill, to assess virtually everything that's done: regional planning, local authorities' development plans. Everything is accessible by reference to national planning statements, which are emanations of the minister for the time being, published on websites. And it's that worry that I have, that we are in fact, through the Office of the Planning Regulator, dragging back from local authorities the tiny areas of discretion which they actually enjoy at the moment. You know, the European Charter says that the executive in local authorities is answerable, responsible to the elected members. Well, that's true up to a point, but it's untrue in substance. In many respects, the local authorities are not really in command of their executive. They can get answers from them, and in that sense you can say it's responsible, but they can't, in so many areas, direct anything in particular to be done by their planning executive. And if I could just draw the House's attention to what we're doing with the Office of the Planning Regulator here, at page 651 in section 499, we're saying that the planning regulator shall, subject to this part, be independent in the performance of his or her functions. And that sounds good. Here's a person who's supposed to be independent. And a lot of this flows from the decisions of the tribunals who were concerned about corruption in local government and the corruption of the potential for corruption of elected members in relation to zoning matters and the like, and the outcome of the various tribunals suggesting that there had to be some kind of policing of the manner in which planning decisions were made by members of local authorities. I have no problem about accountability or ferreting out corruption, but it doesn't seem to me that that means that, that an independent officer effectively takes over the role of micromanaging and supervising the manner in which local authorities carry out their functions. And having said that the Office of the Planning Regulator is to be independent, at section 594, the House should note that the Office of the Planning Regulator shall, in performing its functions, have regard to the policies and objectives for the time being of what? Of the government, including national planning statements. So it's not just that national planning statements are the only thing that the OPR is supposed to have regard to in carrying out its functions, but day-to-day policy statements by the government are to be matters which the planning regulator has to pay attention. And then you ask yourself, you know, well, what's left? What's left of this charter of local government? What's left of the principle that we all apparently signed up to in the 1980s and amended our constitution to recognise that we would give the maximum devolution of self-determination to elected bodies as provided for in the manner that I mentioned, if in the end, you know, the government's policy can trump virtually anything. Why are we doing that? And my rooted objection to what we're doing with the OPR is that it is effectively the enforcement agency for a one-size-fits-all policy across this island. Now, I know that in the planning statements and planning guidelines that this Act envisages being brought about, there will be differentiation between, say, urban areas and rural areas. But I don't believe that the planning requirements, say, of Galway County Council are the same, are the planning issues they face are the same as those in, say, Kildare. Kildare now has a huge population, massive population, and it's part of the greater Dublin conurbation for many purposes, though not for all. But across rural Ireland, depopulation is gathering pace. Local GAA clubs are losing members. They can't field teams. Local institutions, shops, banks and facilities, Garda stations, are melting away like snow on a ditch. And it strikes me that if I were a Galway County Councillor, I wouldn't want to be bound by ministerial statements, planning statements, in relation to housing densities and issues of that kind, which may well be suitable for some parts of the country and may well not be suitable for others. And I know there's a provision for regional diversity, but even within the regions, there's such a massive diversity between rural Wicklow, for instance, and Bray. Such a huge divergence in terms of what local planning requires. So this amendment, and I've tabled a whole pile of amendments, and I don't apologise for doing it, objecting to the references in this legislation to the Office of the Planning Regulator, because I believe that we are strategically making a very, very significant blunder in this legislation. This office, by the way, once you're appointed to it, it has to be on foot of a competition run by the public appointment system. You can't be removed if you're the Office of the Planning Regulator except for stated misbehaviour. And subject to these very strange provisions that you're obliged to have regard to government policy, you are effectively being put in the place almost of the Director of Public Prosecutions. And there is, in case people think I'm exaggerating, there is provision in section 508 of subsections 3 and their remaining sections for the OPR to send people, to send reports to the Garda Síochána and to the Standards in Public Office and the like to supervise the actual day-to-day complaints in relation to the day-to-day activities of local authorities. So I ask myself, are we enacting a law which is increasing the power of the department coupled with this Office of Planning Regulation and decreasing the discretions and the devolved freedom to determine what local government requires, which is implicit in the Council of Europe Charter, which we signed up to and to which we gave nominal obeisance by amending our Constitution to bring in Article 29A. And I have to say that although I admire the determination of the former Attorney General and of those people who think that the time has come for a major change in planning law to stop some of the nonsense which has the protection of bats put so high compared with the housing of people. And people have found bats in parts of Dublin that they never knew there were bats in before, I can tell you that. And there are experts running around Dunleary trying to find bats and putting up microphones to see can they hear bats in any part of Dunleary in order to object to planning applications and to foot trip the planning process. And there are people who have made money out of objections to planning developments in which they have no real legitimate interest. I accept that all of that needs to be addressed. But I'll finish on this point. I put down all these amendments, and I won't keep speaking on them. They're there, and once is enough to move them in principle. I believe the OPR is an overly powerful, overly prescriptive agency. I believe that the powers we're giving to ministers through their statements and the particular provision that I find most offensive to me is that this person who's supposed to be independent in his or her discharge of and the office's functions, that they are obliged by statute under Section 504 to do the following. The office shall, in performing its functions, have regard to the policies and objectives for the time being of the government, including national planning statements, but not limited to them. Any policy is something which the OPR is required to have regard to. I mean, I know that it goes on to mention the policies of local authorities, but I just wonder, why are we elevating the government's policy to such a height that the agency which decides whether or not particular provisions are or are not consistent with national planning strategies or regional planning strategies, or whether county development plans are or are not in conformity with them, or individual planning decisions are in conformity with them, is to be decided by reference to something as loose as government policy. That, in my view, is radically opposed to the principle of the Council of Europe's guarantees for the autonomy of local government. And I didn't have an opportunity at second stage to speak in this House on the matter, and I placed all these amendments down to be an opportunity on which I could make that point. I think that the time has come to loosen controls in Ireland, to say to Galway County Council, allow more one-off housing if that's what you actually think is necessary. And it doesn't really matter if the Office of the Planning Regulator in Dublin thinks that one-off housing in Galway and one-off housing in, say, Wicklow are two very different things and could have two very different, diametrically different effects, and one might be a good thing and one might be a bad thing. I believe that the time has come for us to respect local democracy more and to give local authority members real control over what they're doing, and the right to determine the shape of the communities that they want to create without this massive supervision and massive set of constraints which have been put down, I think, as a huge overreaction to what the Flood Tribunal uncovered in relation to planning issues, particularly in the Dublin area. I think that, you know, someday somebody will stand up and say, how did we get here? And unfortunately, this massive bill, which we have to consider in fairly tight parliamentary time constraints, that this massive bill, I think, represents a decisive step in the wrong direction. Thank you.
Thank you very much. I'd just like to acknowledge